Professional ethics. Question answer. What is meant by professional ethics? Professional ethics is the personal and corporate rules that govern behavior. What is meant by professional misconduct? Violation of rules and boundaries set by the governing body of a profession. Dereliction of duty, disgraceful behavior, dishonorable conduct not benefiting advocate. In which year Advocate Act was passed? 1961. What are the qualifications required for an enrollment of advocate? As per section 24 of the Advocate Act, he must be a citizen of India, completed 21 years of age, be a law graduate of recognized university and paid the prescribed fees. LLB plus 21 plus citizen. What are disqualifications of enrollment of advocate? As per 24A of the Advocate Act, if he is convicted of an offence involving moral turpitude, he is convicted of an offence under the provisions of untouchability. What is the enrollment procedure for advocate? He must be qualified under section 24, should follow instructions prescribed by State Bar Council, pay the fees. Which authority is having power to enrollment of advocate? State Bar Council is having the power to enroll advocate. What are the classification of advocate under Advocate Act? There are two types of advocate, senior advocate, other advocate, as per section 16. Which authority is having the power to issue enrollment certificate? State Bar Council. What are the privileges of advocates? As per section 30 of the Act, right to practice before any branch, any tribunal or any authority. What are the privileges of senior advocates? Senior advocates are the privilege without filing the Wakalatnama, he has to argue on behalf of any advocate. Which article right to profess? As per Indian Constitution 19(1)(g), right to a profession. Which section deals with the right to practice? Section 30 Advocate Act. What are the functions, powers and duties of Bar Council? Functions: lay down standards of professional conduct and etiquette, safeguard rights, privileges and interests. Powers: filling casual vacancies in the Bar Council, organizing legal aid and advice to the poor and functions of committees. Duties: duty towards bench, duty towards client, duty towards opponent, duty towards colleague, duty towards public, duty towards nation. What are the 7 lamps of advocacy? Honesty, courage, industry, wit, eloquence, judgment, fellowship. Honesty, courage, industry, wit, eloquence, judgment, fellowship. What is propounded as 7 lamps of advocacy? Who propounded? John Abbott Parry. What is the 8th lamp? Tact, given by Krishnaswamy Iyer. What is industry? How is it related to advocate profession? Industry is the quality of hard work, being always employed usefully. Advocacy is an intellectual profession. Advocate must be work hard every day like industry. His knowledge of law must be up to date. He shall never ignorant of current law. What is courage? Courage is the quality that enables a person to control fear. In face of danger, misfortunate, an advocate must possess courage. No fear about any authority. It is the duty of advocate to fearlessly uphold the interest of his client by all fair means, without any fear of unpleasant consequences to himself or to others. What is the dress code? White suit, white pant, black blazer, black gown, and a white band. What is wit? Wit means clever and humorous expression on idea. Wit flows from intelligence, quickness of mind. A lamp of wit is needed to enlighten darkness of advocacy. What is eloquence? Eloquence means fluent speaking and skill, full use of language, and success of an advocate depends on his eloquence. What is judgment? Judgment is intellectual capacity to define right from wrong. Judgment means study of a case in depth. What is fellowship? Fellowship means membership in a friendly association or a compassion. What is the duty of advocate towards client? Shall be fair and reasonable and submit the case on behalf of his client. Duty of advocate towards opponent: shall not mislead the opponent or put him on a wrong scent. What are duties of advocate towards court? Shall not criticize the judiciary with malice, shall not mislead the court, should have pleasing manners. What are the advocate duties towards client? Accept the brief, file the case before court, maintain respect, explain consequences, shall not act on instructions of any other person. Duties towards colleague: does not interfere in the respondent's agreement, cooperate with other advocates. What is the duty of advocate towards nation? Shall uphold the integrity and unity of India, protect fundamental and human rights, and respect Constitution of India. Duty of advocate towards public: compose family differences, settle petty disputes by amicable settlement, shall work with social welfare committees to promote social order. Remedies for misconduct: review, appeal, apology. What is the period of disposal at SBC? 1 year. If it is not cleared within 1 year, it will go to BCI. Aggrieved person, decision of the State Bar Council, appeal lies to Bar Council as per section 37. Aggrieved person, the decision of the Bar Council, appeal lies to Supreme Court as per section 38. What is meant by contempt of court? Willful disobedience to any judgment, decree passed by court, or saying any words by mouth or signs which are insulting the judiciary system. However, the punishment of contempt of court 1971, simple imprisonment which may extend to 6 months or 2000 or fine or both. What are limitations for contempt offences? 1 year. The court is having power to punish for contempt, High Court and Supreme Court. Which court is having more power than contempt offences? High Court is having more power because during the period of emergency, President suspended the fundamental rights. Jurisdiction of Supreme Court under Article 32 was harvested during emergency. How many types of contempt of court? Civil contempt, Section 2B, criminal contempt, Section 2C. What is the jurisdiction of High Court and Supreme Court for contempt? High Court as per Section Article 215, Supreme Court as per Article 129. Which article deals with legal aid? Like Article 39A of Constitution deals with legal aid. How to maintain bar-bench relationship? To maintain cordial relationship with Bar Council and the bench. Either advocate or any other person shall punish under Contempt of Court Act or not. Yes, every citizen of India shall be punishable under the Act. Who are eligible for free legal aid? Who are below the poverty line? Women and children, mentally ill persons, scheduled caste, scheduled tribe. What is meant by ethics? Ethics means morals, branch of philosophy, dealing with values relating to human conduct. What is meant by etiquette? Etiquette means rules regarding profession, customary code of polite behavior in society among members of particular profession. What is meant by law? Law is a bundle of rules recognized by public, implementation and administration of justice. Legal services not to be provided in certain cases. Defamation case, malicious prosecution, personal charges with contempt of court proceedings, proceedings relating to any election. Advocacy profession, whether it is a business or not, no. It is a noble profession, not a business. Who is an advocate? Enrolled is named in the State Bar Council and practices under bench. Who is a solicitor? Who is having heavy knowledge of law and prepare legal document, not practicing. What are functions of State Bar Council? Admit persons are advocate on roll, safeguard the rights and privileges interests of advocate, perform all other functions. What is the punishment for misconduct? Section 35, reprimand, suspension, removal of the name or fine. How many categories of legal practitioners, traders and wakils? Before. How many types of writs? There are 5 types of writs. Habeas corpus, produce the body. Mandamus, we command, please do it. Certiorari, certified, to be certified. Correct illegality of a decision or a jurisdiction, lack of jurisdiction, certiorari. Prohibition, quash the decision already taken. Quo warranto, question of title to the holder of office under what authority? Examples of professional misconduct. Appearing for both sides. Second, changing sides during appeal. Bribing the judge. Furnishing false information to the judge. Dereliction of duty. Handing over brief without client's permission. Professional negligence. Misappropriation of the client's money. Seeking repeated adjournments. Making false allegation against the judge. Deliberately lodging groundless complaints. Making groundless and insulting charges against the witness. Refusing to accept a case without justification. Attending court in a drunken state. Attempting to influence judge for orders. Carrying other trade or business full time. Committing crime under IPC. Financing litigation and sharing the bounty. Obtaining client's signature on blank papers. Shouting slogans. Holding strikes in court. Approaching IO for favors. Writing letter to presiding officer in a pending case. Tampering with the witness, including wrong person. Moving application before any court without informing similar application is pending elsewhere. An exclusively retained pleader accepting a case against the client from opposite party. Failure to appear in proceedings of case without sufficient reason. Retaining the judgment copy of the trial court with himself with the intention of getting job to appeal, accusing partially or bias against presiding officer, partiality, tampering with records or witnesses, writing letters to persons for soliciting cases, advertising about his profession, taking advantage of ignorance and illiteracy of the clients, misappropriation of the decreed amount, giving wrong advice to the client, taking money from client from bribery, suppressing the truth, indecent cross-examination, contempt of court, false identification of the deponent, gross negligence, appearing on a forged wakalat, failure to attend trial, attesting forged affidavits, abstaining from court appearance, misconduct is defined as unlawful behavior or negligence act by a public officer affecting the parties' rights. Misconduct is not capable of precise definition. It may involve in general moral turpitude, improper wrongful behavior, willful act against the norms, forbidden act, transgression, disobedience of accepted professional norms, act unapproved by the other party, unethical act is done willfully with a wrong intention by the people engaged in the legal profession. Case 1. Dealing with negligence. Sale deed case. Court fees was deficient. Not informed to client. Not took any steps to correct. Suit was dismissed. Not informed to client. Held to be professional negligence and suspended from practice. Case number 2. Case number 3. 302 case, dismissed High Court, accepted to file SLP in SC, got the fees, wrongly affirmed that SLP was filed, sent a forged set of documents as proof of it. No SLP was in fact filed. So case was filed under local bar council. For 1 year no action was taken. Then it went to BCI, held to be misconduct. Then BCI transfer case number 4. Respondent advocate prepared draft complaint, sent it to Commissioner of Police, SHO to begin action. No fees was settled after the notices. Complainant alleged to have paid 4,000. He signed wakalatnama. Respondent asked for bank passbook and demanded 1100 as his fees for filing the case in court. Complainant did not produce the document, changed his mind regarding the case, asked for refund of 4,000, saying he is a poor person. Inquiry made. No proof was given as to payment of 4,000, so case was dismissed. Case number 5. Complainant filed a property suit, appointed respondent as advocate, informed the case was in progress, when in reality the case was dismissed for default. Advocate admitted to the fault, knew of the facts, suspended for 6 months. Case number 6. Complainant was a party in 2 cases. Filed writ. He engaged respondent by paying his brief, handing over case papers. He was informed that writs were duly filed. In reality, writs were not filed. In addition, he threatened the complainant. So BCI found the respondent guilty and suspended for 6 months. Next, case 7, vicarious liability for act of a partner. The bank entrusted the work of recovery against a borrower to a firm, partnership firm of advocates. One of the partners took up the case, took the file, and took the original documents also. The plaint was returned for rectifying defects and plaint was not re-represented. Strictures was passed by Supreme Court. Only the partnership firm said only one partner has taken up the case, the other partner is not vicariously liable. BCI held the partner liable on professional misconduct, suspended for 5 years. Negligence in conducting a case, case number 8. A civil suit, 11 documents filed, okay. One a compromise, complainant engaged another advocate. Other advocate found 2 important documents missing from the court documents. Respondent did not try and find the papers. Punishment, reprimand. Case number 9, negligence in conducting a case. Complainant obtained temporary injunction to stop her husband's second marriage. Main suit was dismissed for non-prosecution. Her husband remarried. Negligence of respondent. Advocate alleged for non-prosecution. Admitted non-prosecution. The local bar council reprimanded for misconduct. Bar Council of India set aside the punishment as the wife did not allow the case to be taken up against the husband after the marriage is over. Case number 10, negligence and inordinate delay. Complainant couple signed a purchase agreement with estate agent and paid advance. Estate agent due for them. Complainant engaged advocate, paid 3,000. He did not initiate any legal action. On his own, complainant recovered the money. Complainant asked for refund of the fees. Advocate did not repay. BCI found the fees was not refunded, but asked for the fee to be refunded. Once refunded, no punishment. Negligence not amounting to misconduct. Disclosed privileged information to third parties. Advocate disclosed privileged information to third party, plus he wrongfully identified a woman in case of attestation, and he was also a real estate agent. Complainant failed to prove the mens rea, hence case dismissed. Case 12. Negligence not amounting to misconduct. Complainant entrusted files and records to respondent for filing 2 cases against the stock exchange and for non-delivery of shares. The files contained admission of liability. He admitted acceptance of the 2 files, advised out-of-court settlement, which did not materialize. He shifted his location outside Madras, and he returned first file, did not return second file. The missing file, he contended, did not contain any important papers. So losing papers was accepted. It was held to be negligent, but costs were awarded only. Held it not to be misconduct because the file did not contain important papers. Case number 13, negligence not amounting to misconduct. In a suit, negligence during a case, he was hospitalized and filed for compensation under MV Act. Through a clerk, negotiation was done regarding fees. No case was filed. Respondent denied soliciting the case. Respondent admitted being hired. He returned for want of hospital bill details. Complainant letter asking for return of the papers. Respondent contention was that he collected the FIR, but SBC DC rejected the contention because no FIR can be collected by an advocate. No proof of substantial injury was given by the complainant, hence not guilty. Case number 14. Complainant entrusted a DP note to the respondent to issue notice to the debtor, paid the fees. Notice was issued. Complainant demanded notice back so that he could arrange for another advocate. Advocate refused. Advocate said, exercise the right of lien because he wanted fee to be paid. Then, document not being returned, it is amounted to misconduct. SBC ordered with the cost of 1,000 rupees. Case 15. Failure to send accounts, misappropriation of money, withholding of document. Complainant on the years entrusted rent control case over the years to the advocate and alleged financial irregularity. The respondent proved that he was arranging loans. He used to collect the rents and repay the loans and give a statement of account. Based on this, SBC dismissed the case. Misappropriation of client's money. Case number 16. Complainant, his husband owned some house which was submerged in Srisalem project, and compensation of 2.8 lakh was deposited by the government in sub-court. Respondent advocate represented the complainant's husband while visiting the respondent. Her husband went missing. Advertisement was issued in the newspaper by her brother-in-law. Meanwhile, the compensation amount was deposited in the complainant husband's account by the court. Complainant requested the respondent to help her clear the amount from the bank. He agreed but didn't act. Later, complainant came to know compensation amount was withdrawn by forgery by the respondent advocate, posing as her husband. He claimed the money from respondent, but he refused. Sent a legal notice. Misappropriation of money was held to be misconduct. Complainant was not appearing personally before BCI at New Delhi. Because of non-prosecution, the case was lost. Next, breach of trust. Complainant case. Complainant and GPA holder of his mother-in-law during her lifetime and legal representative of her death. Respondent advocate prepared his will and issued a custody certificate of holding the will. Later, the lady changed her advocate. Respondent refused to hand over the will to other lady or to the new advocate. Lady got a new will prepared by the new advocate. BCI held breach of trust, guilty of misconduct. He was suspended for 1 year. Supreme Court cases. N. Chaurasya versus M.R. Murali. Relationship between the appellant and the respondent, landlord and tenant. Was initiated, rent control procedure was initiated by the respondent against the appellant. During the pendency of the case, 3 instances of physical assault happened, one in the court. But the case was not followed up by the tenant advocate. Because it was not followed up, no case could be made out and the case was dismissed. Next, case number 2, Supreme Court, H.C. Tiwari versus Baiju. It is led to removal from roles because of misappropriation of a client's compensation money. Client was a poor illiterate person and using the money for 11 years and lying on it regarding collection. It is regarding land acquisition. So he was removed from roles of advocate. Next, case number 3, M.B. Penangsharappa versus K.G. Ishwar. Penangsharappa versus K.G. Ishwar. Appellant engaged a respondent advocate to file a suit against Siddarama Shetty for recovery of 60,000 on the basis of a DP note. Shimoga. The property of Siddarama Shetty was got attached by a court order. The suit was compromised. Attachment of property continued prior to it. Then the advocate appeared on behalf of Siddarama Shetty for the same property but in a different case. He did not inform the original candidate. It was held to be an obligation and not exactly professional misconduct because he appeared in a different case at a different point of time. So case dismissed. Case 4, Supreme Court, Narayan Pandey versus Pannalal Pandey. The advocate was alleged to have involved in a number of fraud cases, forging, fabricating documents without the knowledge of the partners, entering into a compromise in a consolidation court, and collecting money without knowledge of the original parties. So, there were 7 witnesses. State Bar Council did not take into account the 7 witnesses. State Bar Council took into account the 7 witnesses. The Bar Council of India did not take into account the 7 witnesses. And Supreme Court again referred to the 7 witnesses in their deposition and punished for forging and fabrication. 3 years suspension without cause. Case number 5. Ashwini Kumar Upadhyay versus Union of India. It is a writ petition under Section 32 and Article 32 of Constitution of India for issue of writ of mandamus to debar legislators from practicing as advocates during their parliamentary legislative tenure. It was discussed and held that MP MLAs are not employees of the government and hence the restriction imposed by the Bar Council of India on employment is not applicable to them and they cannot be stopped from practicing in courts. Next, Supreme Court case BP Sinha Gajendra Gatkar. Case number 7. Rajendra Pai versus Alex Fernandez. The appellant on the rolls of Maharashtra Bar found guilty of professional misconduct. His name was removed from the state rolls. Appeal was dismissed. Supreme Court it was mercy petition. There was a case of 150 persons under land acquisition villages, out of which in case of 3 persons it was found that the advocate has forged the signatures of those 3 persons, giving false identification. Supreme Court held that it is punishment of 7 years is sufficient because only in 3 out of 150 cases he has done wrong and rest of the 147 cases he conducted properly. Case number 8. Ashok Bhan judgment. Appeal against the order of BCI removing the name of K. Satyanarayana, delinquent from the state rolls, as he was found guilty of professional misconduct in discharge of duties as advocate. The decretal amount was collected by the advocate but did not pay to the claimant. Cost of 5,000 was imposed and amount was repaid. B. Sunita versus Telangana. Judgment of A.K. Goel. Husband died in a motor accident. She filed a claim under MSCT to respondent advocate. Compensation ordered. Paid a total fee of 10 lakhs. Advocate demanded 3 lakhs more. He took a check and also demanded 16% interest. He held that the check bounced and then held it to be a legal debt. And the BCI decided, Supreme Court decided that it is not a debt and the fees regulation is to be done by the Parliament, not by the court. But it still amounted to professional misconduct. We are asking for a percentage of the amount. In the case of 10, Jaipur Vikas Pradhikaran, JVP versus Ashok Kumar Chaudhary. Here in this case, Ashok Kumar Chaudhary was an advocate for Jaipur Vikas Pradhikaran, government body, regarding land acquisition. He has acted fraudulently by substituting his own relatives in place of the persons whose land was acquired and fought the case against himself through others and lost the case, and which made the amount to be payable from few thousands to few crores. He was suspended for 5 years. In the case of judgment given by B.V. Nagaratna, Anjappa versus Krishna Reddy. Anjappa versus Krishna Reddy in Supreme Court. Here it is against the state bar councils who are not prosecuting the professional disciplinary proceedings filed with them and keeping them pending for more than 1 year. So that automatically by rule of BCI, the cases were transferred to BCI. And mainly the cases were against office holders of the state bar councils. So the court held that to be a professional misconduct of the bar councils themselves, state bar councils, and asked them to cooperate with the Supreme Court and the judicial system. Next, the Supreme Court case Yatin Narendra Ojha versus High Court of Gujarat. He was both the president of Bar Association. His senior gown was withdrawn unanimously by the Gujarat High Court because he was unnecessarily making offending comments against the High Court judges and writing offensive letters and circulating it in his WhatsApp group. Next, Supreme Court case, Prashant Bhushan case, suo motu contempt petition. Factors relevant for the sentencing are offender, offence, conviction, judgment, statutory other defence, justice, truth, bona fides, and public interest. Prashant Bhushan is a well decorated lawyer engaged in many pills, but he sent a few tweets against the ex-chief justices of Supreme Court, and not only distributed these tweets under various groups but also spoke about them in media. So the Supreme Court has taken suo motu notice and punished him with for 1 rupee as fine. Next, Supreme Court case Vijay Kurle. Regarding Vijay Kurle, was the president of Bombay Bar Association, president of Bombay Incorporated Law Society. He made scandalous allegations against the bench, and they have not denied the author being the author of the letters. Tenor of the letters was highly disrespectful, scandalous, scurrilous. Suo motu contempt was taken and punishment given. Another Supreme Court case of 15, Arun Mishra bench against the District Bar Association versus Ishwar Sandilya. The District Bar Associations were resorting to strikes and not attending courts on Saturdays. This was held to be a violation of the code of conduct, and everybody under Constitution Article 144 should help and aid the judicial process in India. Next, Court 16, Supreme Court, Union of India versus Tarsim Singh. Batch of appeals by Union of India to question High Court of non-grant of solatium and interest to the lands acquired under National Highway Act. So, solatium was not being granted. It was ordered that solatium should be granted to the owners.